Good morning. How's everybody doing? We're glad to have you. It's great to see so many familiar faces. It's fantastic. Notice the Honorable Claude Sitton is here, the director of the Burke County Museum. Thank you for coming, sir. We have some great upcoming events, and if you'll take a look at the green sheet that's on your seat, or sheet that's on your seat, you can peruse that at your convenience. How's that? Oh, that's right. I have a separate one, but the sheet there will work. That's right. This is the fancy sheet. And also, please swing by our booth at the Blackberry Festival this weekend. We love talking to you guys. We always walk away with some great stories about Caldwell County, and so swing by and chat on Saturday. I'm extremely proud to bring up the man who really doesn't need too much of an introduction at all. He has spent the majority of his life studying and contemplating law, and will be presenting on the U.S. Constitution today. And I can't wait to hear his insights and some of his ideas. So, as always, the informative and entertaining Judge Beverly Beal.
Thank you very much. Hola, thank you. I appreciate that. It's good to be with you. I'm especially gratified that my dear friend from Burke County, Jo Bailey Sitton, is here, and she brought Claude with her. Stand up, Claude, and take a bow. He is the director of the museum. What's the name of the official name of your museum?
The History Museum of Burke County.
Of Burke County. The History Museum of Burke County. Yeah. And thank you for coming over, and thanks to all of you being here. I hope you'll find this interesting. There are several of you and Claude is one of them, in the room that probably know more about the Constitution than I want to delve into with any confidence at all. But I think we're going to talk a little bit about it. But you see, the important things are on the screen first. That's my grandson, Granger, who's seated right over here now, and my wife, Judy. Granger is, how old are you, son? 14. Now, the trick now is to find the right thingy here. Okay, so we're going to... give me a moment. We're going to be talking about the Constitution. Now, I am not going to be dissecting the Constitution as a document. We're talking history here, folks. And my main theme is history. I will try to give you some insight into a few of the particulars of the Constitution, but mostly we're going to celebrate the Constitution. Now, this is July, and we think usually about the 4th of July, and we think about the Declaration of Independence, an important document to be sure. It marks a birthday, and we don't associate with the Declaration the ongoing process of our government or our history specifically, but the Constitution we do consider the foundation of our form of government. So we're going to talk about the Constitution today. Now let's talk briefly about the need for law in every society. Families, tribes, communities, religions, schools, towns and villages, states, nations, and in international relations, there must be law. There must be law. So what do we mean by law? Here's what Merriam-Webster says the law is: a binding custom or practice. Now I'm not going to read it to you. You can read it. You see it. That's the dictionary version of the word Constitution. But here's what Claude Sitton and I learned at the feet of Dr. Lee at Wake Forest Law School: a body of rules enforceable in courthouses for the breach of which remedies are provided. Do I hear an amen, Judge? That's what you learn, along with a phrase that was used last week for the first time in decades in my presence: incorporeal hereditament. Now, we're not going there. That's something else. But the lecturer who's trying to pronounce it had to ask me how to pronounce it. I felt real good because we learned it at Wake Forest. Definition of law, we've just covered. American sources of law: the common law, constitutions, legislation, judicial decisions. Now, that's just an overview, but how many of you know what I mean when I say the common law? One, two, Claude does, one or two of you do. And my son and my son John's here too, right over there. So they know what common law is. I've talked about it. It's the law that was initially promulgated by the judges of England, when those judges had to decide what a rule would be in particular situations that would be applied common to every case throughout England. They had to get together and talk. They wound up usually getting together every few months at the Cock and Bull Ale House somewhere near London, and saying and comparing notes and talking about establishing a rule, such as the definition of self-defense, those types of things. And so that's the common law. Constitutions, legislation, judicial decisions. Again, I'm going to move through that. So a definition of a constitution now. A written instrument embodying the rules of a political or social organization, the basic principles and laws of a nation, state, or social group. How many of you belong to some social group that has its own bylaws or constitution? Very common. Those principles determine the powers and duties of the government and guarantee certain rights to the people in it. Some historic constitutions, the Magna Carta, the Mayflower Compact, the Carolina Colony Lords Proprietors' fundamental constitutions. That was drawn up by the Lords Proprietors for the colony of Carolina in 1669, and it actually described a utopia. They had great dreams. They did not come to be, but they made great plans for a place for people that was going to be a utopia. Now, modern written constitutions, the Constitution of the state of North Carolina, now, and look at that date, 1776. We're going to be talking about dates quite a bit today. 1776, North Carolina prepared in writing its first constitution. 1788, the Constitution of the United States of America. This is the cover of an old version of the Constitution of or form of government that was adopted in Halifax. The Halifax Resolves, I think, is another name used for it, by the state of North Carolina, by representatives that sort of constitute an ad hoc committee, you might say. And it was a combination of a Declaration of Independence and a constitution for the operation of a government for the people of North Carolina by that time. So let's do a little constitutional, or rather a little timeline. And we're going to use 1653. Some could say that's arbitrary. The founding of the colony of Carolina. And there's a point here, but just think about what we see here. Time, how much time passes. 1776, the American Revolution begins. 1777, the Articles of Confederation are drafted and sent to the states for ratification. Now, the Articles of Confederation, we'll talk about again in just a moment. 1781, the Articles of Confederation were ratified as the war with England continued. So until they were ratified, we did not have a government that covered all the states in any way, shape, or form. Each state was independent of one another in their minds. They just got together to fight a little war, and they planned to go their separate ways. 1781, the Revolutionary War ends with victory. I suppose I should have said victory for us. Somebody always wins, you never know who. 1787, the Constitutional Convention convened in Philadelphia. September 12th, 1787, all 12 state delegations approved the Constitution. Draw a distinction in your mind. The delegations to the Constitutional Convention were representatives. That's just approving the Constitution that had been drawn up. It still had to be approved by the states, didn't it? But that's when all 12 delegations approved the Constitution draft. So we go down through history. I'm not going to, I'll let you read, but 1787, 1788, those years were momentous years in regard to the ratification of the Constitution. Notice in bold type, Rhode Island just rejected it the first time around. Now, yeah, they were worried about it because they were a small state. Yep. Then we come to the Virginia ratifying the Constitution. New York ratifies it. North Carolina rejected it. North Carolina rejected it at a meeting that was adjourned or was convened in Hillsborough. And they didn't reject it in the sense they said we rejected. They just adjourned without doing anything. That's basically what they did. And we'll talk about that. 1789, Congress approved 12 amendments. How many amendments are there in the Bill of Rights? 10. Well, they sent 12, and 10 were approved. Now, the Constitution was in effect at that point because enough states had ratified the Constitution, 9, to make it effective for the states that did ratify it. But once those amendments were ratified and adopted, North Carolina ratified the Constitution in 1789. And finally, Rhode Island came around. The Bill of Rights, the Bill of Rights is important because without it, we probably would not have been able to get the agreement of the states. Once there was a promise made to adopt amendments that would protect individual liberty, personal rights, then the states started getting on board. They had to have that promise. And then when the 9 states did ratify it, the minimum required, those 9 states sent their representatives to the Congress, and the Congress started this process, and that was the reassurance that eventually brought North Carolina into the fold and Rhode Island by a close vote. And it's very interesting to note that everybody in Rhode Island voted. There were only 66 there. How long did it take? 1653, founding of the colony of North Carolina. 1789, North Carolina ratifies a new form of government, that is, the U.S. Constitution. 136 years. 136 years. Why did it take that long? I'm not going to try to answer the question, I'm not going to try to answer it in depth. But of course, there were more important things. If you lived on the frontier, if you lived in a cabin somewhere in even Rowan County at that time, it was a struggle for survival. And law was already present in the form of the king's judges and justices. There was a system of laws that protected people, but it took that long. And of course, George III decided to upset apple carts, and that caused the rebellion, but it took 130 years. How long did it take from the beginning of the American Revolution? Now, in 1776, we say the beginning of the Revolution. I should have said from the Declaration of Independence, because battles had been fought in this rebellion in 1775, hadn't they? Concord, the Battle of Concord, the Tea Party, those events preceded the Declaration of Independence. 1790, the Constitution is ratified by all 13 states. 14 years. Once they got rolling, folks, they really moved. 14 years seems like a long time to my grandson. But to us old people, not that long, is it? 14 years. But they were intense, and they had good, educated leaders. And I emphasize education. We'll see that theme as we go through here. But when you have educated people who can think and reason and analyze the situation, things move faster. So what did they do when it came time to do something? First, the Articles of Confederation. Now, again, I'm not going to read it to you, but that was drafted in 1776 and was sent out to the colonies for approval in 1777, and the formal ratification occurred in 1781. It provided some government, some cohesive sense to these 13 states. Anywhere else in the world, if you use the word state, you're talking about a sovereign state. Where is Monte Carlo? What's that? Monaco is a state. Luxembourg is a state. In the minds of everyone else in the world, when you use the word state, you're talking about a government, independent and sovereign. We use the word differently in the United States. And that still confuses some people in other countries. But there were problems with establishing a national government. The revolution was intended to obtain freedom. Those colonies said, we want to be independent of the crown and we don't want any central government. Some states considered themselves to be totally independent, and the weaker states feared that the stronger states would have more power than others in a central national government. Rhode Island, for example. So the solution was the Articles of Confederation, and it was intended to create a weak central government, and it did create a weak central government. The central government had no power to over trade between states. It had no power to impose any taxes. It had no power over individuals in the states. The central government could only request money for its expenses, for its operation. Request, not demand. Couldn't tax directly. Well, this didn't work out, folks, for the obvious reasons. There were too many fusses and fights between the states. Boundary lines, taxes, tariffs. If you had a seaport state and you wanted to take goods to a state, and I'm trying to think of one particularly, that does not have seaport locations, there were taxes and tariffs to pay, that sort of thing. So the Congress of the Confederation asked for a convention to consider amendments to its Articles of Confederation. That's where they were going. They were thinking, let's amend the Constitution. So they appointed, they ordered a convention, and the states appointed their delegates. And so there were 55 of them, and the average age was 42. Now, prominent members were George Washington, James Madison, Ben Franklin, who was 81 years old. And the authorities say he was there for morale mostly. He wasn't a real participant, but to have Benjamin Franklin around meant you were blessed. You had the blessing of Ben Franklin on what you were doing. It meant something. Now, who was not present? Thomas Jefferson and John Adams. They were holding down embassies overseas. I'm sure they were in communication, but it took months for a letter to go across the ocean, didn't it? But they were not there to participate in this, as they were the Declaration of Independence. So only 12 state delegations participated. These are organized pretty much by, and it was interesting to me that when I looked at a source for this, they're geographical from north to south. Those were the states that participated in the Constitutional Convention convened in Philadelphia. John Hawkins, am I correct that that convention was held in the same place in which the Declaration of Independence drafting occurred? Is that right? The Philadelphia, what was then I think called the Town Hall, now it's called Constitution Hall. Independence Declaration was there. So was the very laborious work. This took time and effort. If you just think about this building we're in now, you might envision a similar chamber without electricity, of course, and open windows, and trying to stay as cool as you could in hot weather and as warm as you could in cold weather. But they worked for quite some while. Now, let's talk about the people that represented North Carolina. William Blount from Bertie County, a businessman, a war veteran, Tennessee territorial governor, and later United States Senator. Now, this man was a leader. We can see that. And he contributed greatly to North Carolina's future. At that time, North Carolina included what is now Tennessee, in theory. Don't think any Europeans were living past the state line as we know it today. And that's one reason there's a town called Old Fort, because that was the old fort. That was as far as people got for quite some time. They stopped at Old Fort and stayed there. And they had not gone that far. But unfortunately, Senator Blount got into a land scheme when he became the territorial governor of what was Tennessee then, the Tennessee part of North Carolina. And there's a story that he organized the people of the Tennessee area to a petition to Congress for statehood. Well, Congress didn't really want to talk about it. So he just made it a state. He had a local referendum. They said, we want to be a state. And he says, okay, you're a state. Then he went to Congress and said, we're a state. How about letting us in the Union? Well, they did. But he eventually became senator and then had to leave the Senate because he was caught in a land scheme that he was collecting land in Tennessee. He owned a whole lot of it before that whole process was over. Richard Dobbs Speight from New Bern, governor and congressman. Hugh Williamson, an Edenton merchant and medical doctor. William R. Davey was born in England, educated at Princeton, or what is now Princeton. He was from Halifax County, but he settled in Halifax County. He was a soldier, an attorney, a legislator, the governor, and a diplomat, best remembered as the principal founder of the University of North Carolina. And although I went to Wake Forest, I do have a lot of gratitude for that institution. Don't think much of the basketball team, but I really love the University of North Carolina. I work there at the School of Government from time to time and do some teaching there for judges. Alexander Martin from Salisbury, a merchant and later an attorney. Now these names that you hear now are familiar to you in some ways. We know there's a Davey County, don't we? We know and you'll later hear about Iredell. There's an Iredell County. There's a Martin County, but it was not named for this Alexander Martin. It was named for the last royal governor. However, when the revolution occurred, there were several counties whose names were changed to obliterate the memory of the royal status and the colonial status. But they left Martin County's name Martin County because of Alexander Martin. The story is, they said, well, we ought to change it. No, wait a minute. Alexander Martin's a fine fellow. We'll just leave it Martin County and let people assume it's for him. That's the story. So here they are. Williamson, Blunt, Martin, Speight, and Davey. They go to Philadelphia on behalf of the state of North Carolina to enter into these events that were intended to craft amendments to the Articles of Confederation. I do not think it took them long to decide, we're not going to go there. We're just going to start over. We're going to create a product and we're going to sell it to our people and we're going to just start over and do some new thinking. But now, new is a relative term. A while ago we talked about all these different constitutions. They had something to draw on. They weren't creating this out of whole cloth, as my mother used to say. They had guidance from the Magna Carta. They had guidance from other sources, including the Constitution of the state of North Carolina of 1776. They had patterns to go by. What they had to do was try to even the playing field and reassure every individual state that in some way the small states would be protected and the large states would not be punished for being large. They had to work it out so there would be fairness and justice in the document. They knew how important it was. Just think about the pressure on these people. Once they decided we're going to do this, they stayed at it. And they did not all agree on what the finished product was to be. So, let's talk about the ratification debates. Now, I mentioned a while ago the Hillsborough Convention of 1787. Now, that was a rowdy crowd. And what resulted from it was, well, first of all, let me get through this. St. Matthew's Church in Hillsborough. From 21 July until 4 August, 270 delegates from the state of North Carolina. They're presented with this document, proposed as the constitution of a new government for the 13 states. And they spent that many days, 14 days, getting into it. There had been a special election mandated by the General Assembly. By a margin of 2-1, the Anti-Federalist candidates outpolled the Federalist adversaries. So, going into this meeting, there already were teams. You know, you pick sides. And it already developed to the point that you had the Federalists, which was in name a political party. It didn't last very long, but it became tantamount to a political party. And you had the Anti-Federalists, who were against surrendering any local power, and they wanted to be totally independent of any other governments, run their own government. I think they were too contrary to even form a political party. They wanted to be, that's independence for you folks. Now, I'm going to tell a story, and the Baptist in the crowd, I'm sorry, forgive me. Fellow is stranded on a desert island for 7 years, all by himself. It's a tropical island, but it's deserted. Finally, a passing ship sees his signal fire. A rescue party comes ashore. The chief of the boat says, we're here to rescue you. He says, thank goodness I've been here all my whole life, 7 years by myself, nobody else here. And I'm so glad to be rescued. And the chief says, well, I'm glad we could help you, but I see you've done pretty well. I see 3 structures. What's that one over there? He says, that's my house, that's my home, that's where I live. That's very nice, really. What about that one? He says, that's my church. That's where I go to church. That's nice. But what about this one? He says, well, I'm a Southern Baptist. That's where I used to go to church. It's an old story. So look at who the Anti-Federalists are. Willie Jones, David Caldwell, Lemuel Burkitt Thomas, Person is his last name, Samuel Spencer, and Timothy Bloodworth, and William Lenoir are amongst the Anti-Federalists. Now again, you're recognizing names here. Jones County is named for that man. You've got David Caldwell. You've got Lemuel Person. You've got Samuel Spencer. And you've got William Lenoir. Towns, cities, counties named for these people. That's one way you don't forget. That's something that your children need to be taught. Is who's your county named for? Who's your city named for? And that's one of the functions of this place, isn't it? So, I'm just saying. The Federalists included James Iredell, William Davey, here we go, Archibald McLean, and Governor Samuel Johnston. Johnston County? Smithfield, right?
Johnson.
Yeah, Johnson, S-T-O-N?
No, it's Johnson, J-O-H-N-S-T-O-N, down in the county is Johnson.
Somewhere there's a Johnston, and I can't think of if it's not that county, it's something else, but there's something Johnston somewhere. So let's talk about William Lenoir. I don't need to say much about him, but he was an Anti-Federalist. He was a member of the state legislature. You know his leadership, and you know his war record. Now, these are sincere people. He really believed that it was not in the best interest of North Carolina to become involved in the constitutional government being proposed. And Professor Hendrick at Wake Forest, under whom I took several courses, said that in analyzing this subject that the rural representatives to this constitutional ratification meeting were more opposed than the urban individuals, so the individuals from the towns, the New Bern and the established cities. And I think probably General Lenoir was about as far west as you could get. James Iredell. Now, Iredell was the foremost advocate in North Carolina for the Constitution. And he started a public movement in hopes of creating the new government. George Mason was opposed to it. So here we have 2 learned gentlemen engaging in a debate with a great deal of skill over a very important issue. Iredell was the floor leader for the Federalist forces. Now, of course, we're going to learn that this Constitution, as I've already said, did not result in the Constitution being agreed to by North Carolina delegates. But when it eventually was, President Washington rewarded Iredell with an appointment to the original U.S. Supreme Court. William R. Davey was a delegate. It was his motion during the latter meeting that resulted in ratification. So in the debates, the Anti-Federalists feared any distant authority that might threaten state sovereignty. They keep thinking about the King of England, don't they? They still keep thinking about an empire, a royal type of environment. They did not want that. They feared it. The Federalists did argue for an addition of a Bill of Rights. You see, they were trying to get agreement, and they were saying right from the beginning, we understand your concerns about individual rights, and we will go for a Bill of Rights, and the Ten Commandments, the 10 Amendments that eventually were adopted. They understood it. They used that point, and that point did not result in victory at the first convention, but it prevented rejection. It prevented rejection. There was enough argument, there was enough sense in their argument for the Anti-Federalists not to want to push it too far. They were afraid they might lose the vote, possibly. So, on August 1st, 1788, they voted neither to ratify nor reject the document, and the convention adjourned. But the fact that the Federalists from the whole United States wanted everybody in this, when North Carolina's rejection was found to be on the basis of a failure to have the 10 amendments of the Bill of Rights, then there was a renewed effort and to create the Bill of Rights, which eventually convinced enough North Carolina delegates in 1789 to approve it in Fayetteville. By then, George Washington had been elected. We were not yet. We had an ambassador to the United States. We were a foreign country from the standpoint of the United States. We had an ambassador. The Bill of Rights had been added to the Constitution. So, let me go back. So those two events had occurred before the Fayetteville Convention. And George Washington was universally accepted as a fine man of great character with a high sense of duty and honor. And he was very popular with everyone. And the Bill of Rights were achieved. So Willie Jones, who had led the Anti-Federalists, refused even to attend the Fayetteville Convention. He knew what was going to happen. There was minimal debate, and the Constitution was ratified by the U.S. by North Carolina in 1789. And you've seen this page before. Now let's talk about the Constitution a moment. And I assure you, I'm not going to do this in depth, as I said. I may do it in a little more depth than I thought I was. I think I've got more time and we'll leave time for questions. And don't expect any answers, but I'll be glad to hear your questions. So we're going to talk about the document itself a bit. And we're going to talk about, for example, the Supremacy Clause, which says that the law of the land will be the law of the United States adopts, and it will not be what people say the states have the right to enact laws inconsistent with the federal Constitution. It can't be done. The Article 4, Section 1, full faith and credit. Each state must give full faith and credit to the laws of the other states, and that is very interesting, and I'm glad that Claude Sitton is here, because there's a case that went up from Caldwell County that eventually went all the way to the United States Supreme Court. Now, it was a case involving a criminal charge of bigamy. Mr. Williams was married. He was not fond of his wife, but he was fond of another member of the community. And so he wanted a divorce, and he wanted it now. Now, the years we're talking about are right around between 1946 and 1950. I'm going to look at Claude every once in a while because Claude knows about this from a personal aspect. But in 1950, around that time, Mr. Williams learns that you can go to Nevada, stay 6 weeks, and get a divorce. And that is what he did. Well, when he came back, he married I don't remember her name, but we're going to call her Sweetie Face. And he married Sweetie Face. Well, the first Mrs. Williams was unhappy. And so she went to see the district attorney and convinced him to indict Mr. Williams for bigamy. And the district attorney prosecuted that case in the main courtroom of Caldwell County. The case was tried. And he was found guilty. Well, he appealed to the North Carolina Supreme Court. They affirmed the conviction. He appealed it to the United States Supreme Court because if there is a constitutional question involved in a state case, then the case can be appealed to the United States Supreme Court. And Williams is arguing full faith and credit. North Carolina, you must honor my divorce from Nevada, from Reno. Well, the result was no, we don't, from the North Carolina Supreme Court. Appealed from the North Carolina Supreme Court. The United States Supreme Court says, let's take a look at this. And the conviction was reversed. The point being made was that if a person goes to another state to reside there, in order to be a resident of that state, he must have an intent to stay there indefinitely. He must be a really, truly intending to be a resident of that state. And the law was, if you're a resident of the state of Nevada, you can get a divorce in 6 weeks. That's why you had to stay there for 6 weeks and pretend you were a resident. Most of those divorces were never questioned until Mrs. Williams got mad at Sweetie Face. And that's what precipitated this, didn't it? Well, the United States Supreme Court says, well, you do have to give full faith and credit, but the state has the burden of proving that he went to Nevada not intending to become a resident. That's the burden of the state. The burden is on the state to prove the guilt of any defendant beyond a reasonable doubt. So you can try him again, but this time the state's going to have to prove that he went to Nevada but did not have the intent to become a resident of that state. Brought it back, tried it again. What was the result? Guilty. This time the state put on the adequate evidence to establish that point. And he was found guilty. He appealed it again to the United States Supreme Court, and the decision was affirmed. And so that case tried right here, and Judge Sitton knew Mr. Williams. Isn't that right? He was a wonderful man, wasn't he? Whatever.
My daddy's Sunday school teacher.
He was your daddy's Sunday school teacher. Well, folks, there you are. That has a lot to say about our community, but that's why that section is something I wanted to mention. Well, again, briefly outline. We have 3 branches of government. The executive branch consists of the executive officers and the military and regulatory agencies. And of course, I've not been comprehensive, but that's an outline. Congress is composed of the Senate and the House of Representatives. Judicial Branch, the United States Supreme Court and the Federal Court of Appeals, the district courts, and some of the specialized courts, such as the Maritime Court and the Court of Patents. Is it the Patent Court? Yeah, I think that's what we call it. Maybe it's Patents and Copyrights. But now, if you look at the Constitution, and I urge you to look at it, you know you can go online and look at it. Any number of sites give you the text of the United States Constitution. But the Constitution only created the Supreme Court. It does follow that by saying that the Congress has the right to create inferior courts as they wish. They can create them, they can uncreate them, and they can reorganize them. But the Supreme Court is specifically a constitutional office. The North Carolina Constitution says there shall be superior courts. It says Supreme Court, and it always has said a superior court. So Judge Sitton and I have been constitutional officers. You can't get rid of us easy, folks. There's going to be a superior court. there has to be a trial court, and so that's why the Constitution provides that. Now, we talk a lot about checks and balances. There are three equal branches of government. Do I hear an amen? Right. Are they independent from one another? Not really, but we say equal and independent, but they're not. They're tied together. They have to be. They're tied together because of the concept of checks and balances, for one thing, and because it has to have some cohesion. And each branch of government can carry out the functions of the other in certain situations. For example, the military I showed you is in the executive branch of government, but the military has court-martial, and so they carry out a judicial function within the executive branch. The Congress, the Senate, has the power to try the president, impeach. That's where impeachment occurs. And when they sit to preside, the Chief Justice is the presiding officer, the judge for the trial. Do you understand why back there when Mr. Nixon resigned, what turmoil that would create? That was what we were facing at that time. So we have the checks and balances to think about. What checks and balances? Well, the executive branch has the veto power, and the vice president is president of the Senate. These are just a short list, folks. The check of the executive branch on the judicial branch is the power to nominate federal judges and the pardon power. And the legislative branch has checks on the executive branch because they have the taxing authority. And the Constitution says only the Congress can declare war. When was the last time we actually declared war? Right. Since then, there's not been a declaration of war for the combat situations we have had. Checks on the judicial branch, the power to initiate constitutional amendments, the power to create inferior courts, and the approval of federal judges. The Senate approves federal judges. And of course, within the legislative branch, each house has a check on the other. An example is that bills of taxation can only arise in the House. They must start there. The judicial branch has judicial review. We're going to talk about that for a minute. And the Chief Justice presides at a presidential impeachment. Now, let's talk about amendment. We know we can amend the Constitution. How many amendments are there to the Constitution now? 27? I think you're probably right. I never did. I got the book. I don't worry. But at any rate, it's important that you have a Constitution. It's one written document. The British don't even have a written document called the Constitution. They've got a group of documents, but they don't have the Constitution. It's equally important that Constitution be susceptible to and include the procedure for amendment. And not only has there been amendment to our Constitution that many times, there has been a repeal of an amendment. Now, some of you know what I mean. Do you know what amendment has been repealed? Now, the question is, who answered that? You see, write that down, folks. Those are the people, that know about prohibition and the repeal of it, and are happy generally about it. I anticipate. No, I'm not going to put him on the spot, but it was repealed as a social experiment that didn't work out. But now let's talk about individual rights, and in the Bill of Rights: privacy, free speech, peaceful assembly, petition, religion, trial by jury for federal cases. Now, North Carolina just recently passed a constitutional amendment to our Constitution saying that there can be a bench trial, a trial without a jury, by persons facing serious crimes except for capital murder. You cannot have a non-jury trial. And there have been several non-jury trials. But the presiding judge has to approve it and agree to it. The first, I'm not going to read it all, but we're not required to house any soldiers anymore in your homes. That's good news. Sir? Yeah, yes, sir. Yes. I did. I don't now, but I have a book on it somewhere with me. There's a little book that comes from the American Bar Association, a little pamphlet, and it would tell us that if I can turn the pages quickly enough and find it. I tell you what, let me assign that to you. Here's a breakdown of which amendments apply to certain categories. I made some categories. Individual rights were the first 10 plus the 14th. We'll look at the 14th in a minute. Jurisdiction of the federal courts. There's one amendment on that. Election and succession to office. There are a number there. Abolition of slavery, the 13th Amendment. Suffrage. Now, think a moment. That means the right to vote. So you have the 15th Amendment, which was in response to the Civil War and the freeing of those who had been enslaved and giving them the right to vote. That's the 15th. We come to the 19th, and the 19th is going to be in regard to women having the right to vote. Then we have the 23rd, and that's going to be an amendment which changes the voting age from 21 to 18. That's suffrage. You're giving the right to vote. Gee, I hope I'm getting these numbers right. And then you have one more. Can you think of what that last one would be? What group of people in these United States that still did not have the right to vote? What? No. We lived there. The District of Columbia. The people who live in the District of Columbia did not have the right to vote. Did not have the right to vote until the amendment was passed. And John, since you've got it back there, check my numbers out. On the 23rd and the 26th amendments, which one's which? Intoxicating liquors. That was the title of the amendment. For prohibition and then repeal. Taxes, 2 statutes, and congressional salaries, 1 amendment. Now there's the process for amending. You have 2 routes it can go. We got to talk about judicial decision making. I talked about the fact that we go back a long way with the common law. That judges decided what the law would be in some situations. Well, in 1803, after the new country is up and running, we have a situation involved, I think it was Jefferson. Jefferson appointed a man to be a magistrate, Mr. Marbury, to be a magistrate right before Jefferson left office. Madison, the incoming president, says, no, he may have appointed you, but that was back in his administration, and the record of that wasn't complete, it wasn't finished, you don't get to be a magistrate. Marbury sued, and Chief Justice Marshall wrote the opinion from the Supreme Court saying, well, Congress has passed an act, and they had involved in this particular case, that is unconstitutional. In other words, the Supreme Court was deciding that they could interpret the Constitution, and they did. Now, Marbury still lost in this particular case because of a jurisdictional issue, so that was rather crafty, I think. But that was the first case the United States Supreme Court had about interpreting the Constitution. So judicial interpretation now, and remember, Judge Sitton and I have been sitting on the bench in different cases, and we've had to consider these. I think it's rare in my experience, and I think Judge Sitton will agree, we don't make that kind of that interpretation. That's for the appellate courts to do. If we look at a law and say it's unconstitutional, in that particular case, somebody's got to appeal it. Or if we say it's constitutional, somebody's got to appeal it. Let them do that. Very rarely does a trial judge ever come to the point where he's going to do an interpretation of the Constitution. Very rarely. It's happened once or twice. I could tell you stories, and we come close. But always we make a ruling, send it on up. The decision's made by the higher courts. Marbury versus Madison. Another case is Gibbons versus Ogden. Is Mike here? This is Mike's great-great-great-great-great-grandfather, or at least that's what I'm going to say. Gibbons versus Ogden. It had to do with steamboat service and who had the right to grant licenses to steamboats traveling between New York and New Jersey ports. And that was a further development of that concept. So we have two cases there, 1803, 1824, about the ability of the courts to interpret the Constitution. But 1787, we were ahead of the game, folks. In the case of Bayard versus Singleton, Mr. Bayard, the heirs of Mr. Bayard, sued to get back their land, which had been forfeited because they were Tories. Mr. Bayard had fled to England during the Revolutionary War with his family. He died. They came back after the war and said, "We own valuable land and a house. We want it back. You didn't have a right to take it from us. We were children. What did we know?" And Mr. Singleton had purchased the house and lots, and a very beautiful piece of land down on the coast. He had purchased it from the Forfeitures Commission. And so he said, "I own it." Well, it went to the Supreme Court of North Carolina, which consisted of 3 Superior Court judges. That's the way the court system was at that time. 3. One of them was Ashe, for whom Ashe County is named, I'm pretty sure. He tried the case in the trial division, and it was appealed. And the issue was, does the plaintiff have a right to a trial by jury on this issue? North Carolina's legislature, General Assembly, had passed an act that says, if ever there comes a case to court when someone is seeking to recover their property because of the Forfeiture Act, the judge shall enter a dismissal, no jury trial. Well, Judge Ashe had convinced everybody to have a jury trial, and Mr. Bayard lost. He appeals, and at any rate, they said, go back. He has a right to a jury trial. My facts are getting a little hazy on this, but at any rate, he never did get the land. He lost. Singleton got to keep the land. But the question is, does he have a right to a jury trial? So, in that case, Singleton must have appealed, saying he did not have a right to a jury trial. The American Civil War brought into focus several of the civil rights issues and constitutional issues involving slavery especially. But here are some of the issues that have been important to us over the years. And here are the ones I wanted to point out particularly. Search and seizure rights. We see those all the time. Dog sniffing cases. There's a new one down from the Court of Appeals about when the police can use a dog to sniff for drugs around a vehicle and how long you can hold a person and detain them in anticipation of having the dog arrive to sniff and see if they have drugs in the car. That's, by the way, the United States Supreme Court case that just came down. It says you can't do it like you've been doing it. So you have these parts that have created constitutional issues for the courts over the years. Here's the 14th Amendment particularly. And I think it's important to read this when it came up recently in the United States Supreme Court. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's the 14th Amendment. Now, we're going to end up right now with this part, Article 1, Section 9, powers forbidden to Congress. Read that with me now. No title of nobility shall be granted by the United States, and no person holding any office of profit or trust under them shall, without the consent of the Congress, accept any present, emolument, office, or title of any kind whatever from any king, prince, or foreign state. Which means that knighthood that was offered to Judge Sitton, he has to reject. And Elizabeth is a lovely person too, but he had to say no. And I'm glad of that, because I can't think of calling him Sir Claude. But at any rate, you see anything funny about the wording there? Grammar? See any grammar problem with that? Well, it says no title of nobility shall be granted by the United States, semicolon, and no person holding any office of profit or trust under them. Who is them? To whom does the pronoun them refer? The states in the plural. Because when they created this document, they still had in their minds sovereignty of states, independent countries. Them, no person holding any office of profit or trust under any of the United States. It is said that before the Civil War, the phrase would be the United States are something. And after the Civil War, it was the United States is. Now that's anecdotal. According to some authorities, the change took place before the Civil War and continued in terms of language skills, language wordsmithing later, after the Civil War. But the idea is to tell you that it's no longer them. All right, let me stop. Any questions? Yes, sir.
All right. You're required to stay in North Carolina to reach certain age as a Superior Court judge. You have to retire. What do you think about the United States Supreme Court where those 9 people get in there and they're in there for a lifetime?
That's the law. They shall serve as long as their behavior is good. It's what the Constitution says. They serve for life. Most of them take what's called senior status when they get older and don't try cases as much. But of course, that's not true of the Supreme Court. Supreme Court, well, has anyone ever resigned from the Supreme Court? Yes. During the Kennedy administration, Goldberg, what was his name? What? Arthur Goldberg. Resigned. He'd been on the Supreme Court for 4 or 5 years and decided.
My question is, why don't we have that at the state level if it's the national level? You have that. Why don't we have that at the state of North Carolina? Like you're still able to go resign. Why not? Let you keep on.
Well, when I read that the 72, I think, is the current age, but there's a bill to increase that to 75 or something like that. The reason is because the legislature said so. There is no law about it. I mean, no constitutional provision. The General Assembly can create limits like that. They can vote on it, and they did. They said 72 arbitrarily for a while, and I think it's changing. But, well, of course, again, we're talking about Jeffersonian democracy. You know, we're elected. Federal judges are appointed. And you talk about appointment of judges in North Carolina, and the legislature says the public won't stand for it, and they won't do it. So that's part of that. Yes, sir, Mr. Austin.
Well, thank you, sir. Tell me a little bit, I'm putting you on the spot, let's speak off the cuff, about Roosevelt, Franklin Roosevelt's attempt to expand the Supreme Court to 15, and how that was, what that was all about, and how it was controlled.
Well, you recall the what was the name of his IRA? What was it? The act that was passed early in the Roosevelt administration, the National NRA, National Recovery Act. National Recovery Act was passed by the Congress and was put into effect. It included provisions such as the CCC camps, things like that. Well, you get down into the years a while and we start to recover from the Depression, and somebody decides to appeal the constitutionality of the NRA, and the Supreme Court said, you're right, it's unconstitutional, can't exist. And it died on right there. Well, Roosevelt was very angry about that. So he wanted to pack the court so he could have people on that would vote his way. That's not the first time it happened, and it certainly will not be the last. Sometimes it backfires, like Earl Warren was appointed Chief Justice, and events occurred. But that's one of the checks on
Who ruled on that, said, no, he do that?
the Congress. See, there was a big fuss in Congress. Of course, Roosevelt had his allies in the Congress who wanted to adopt it, but that was a congressional issue, and they voted it down. They would not do it. That's where it ended. It did not get to the courts. That's my recollection. Judge Sitton, is that your recollection? Yes, ma'am.
How do we get term limits on our senators and representatives?
They're established by, well, you're talking about the federal. Federal. There are term limits in the Constitution. That's.
They change it, they would have to vote to do it, and then it comes to state. They're not going to vote themselves out of office.
You're right. Of course, what would happen is if someone said, we want 4 years for senators instead, or we want 2 years for senators, and 1 year for congressmen. Well, somebody can propose that as an amendment to the Constitution, and it go through the constitutional amendment process. And would it win or would it lose? I don't know. But those are set, that way. What?
Can you go back to that slide about Gibbons and whatever it was?
Yeah, hold on just a second. Gibbons versus Ogden.
Okay, I wonder if anybody knows who Ogden's partner was.
I don't.
It was Dr. Engel,
Yes, I did. I only slept one. What?
Yeah, the Vanderbilt.
Is that a Vanderbilt?
Cornelius Vanderbilt, right? And he actually stabbed Ogden in the back.
I mean, literally? Yeah, you're right. That's Vanderbilt's business originally was ferry boats, wasn't it?
Yes.
That's right. So that's interesting. Thank you. Elliot Engel. How many of you have heard Elliot Engel speak? He has a lecture on the Vanderbilts, and it is just real interesting about that whole family. Questions? Yes, sir.
Is there a document that preceded the Constitution that had an effect on the establishment of the Constitution?
I suppose the closest you come is the Articles of Confederation. I mean, the Articles of Confederation were there as something to bind the crowd together. It wasn't much, but it was the best they had, or they could get together and get everybody to agree to. And so, as I said, the Constitutional Convention was to amend the Articles of Confederation. But when those men arrived there, they quickly said, we can't do that. It's weak as water, and it's not going to get any better by us trying to amend it. Let's start over.
When the United States declared independence from Great Britain or England,
nothing. There was nothing. There was no document that bound them together, a common cause. And, they had militias. Their militias fought together, but they were still state militias. But they did agree on George Washington being the commander. They agreed on some things, but that was temporary. There was nothing permanent about that organization. Their idea was, we get this war over and we're free from the British, then we all go back to being ourselves. John, did you look up those amendments?
Yeah, one was how representatives are appointed by each state.
Yeah, originally they were appointed.
And the second was Congress giving itself a pay raise.
I better go back and check my numbers then. But yes, Ms. Shuford.
Judge Beal, could you go back to your pronoun, point about the pronoun and the letter that really sells in there?
The slide about what?
Pronoun them.
Oh.
I know that's all about.
There. Yeah.
Let's don't dwell on that one too much, but that's just, I used that to emphasize the fact that this is a nation now. And my father taught me way back in the 60s during the Civil Rights crisis, when one of the states was saying, the governor was saying, I'm the governor of the sovereign state. I think it was Mississippi. And my father said, listen, there is no such thing as a sovereign state. There is no such thing. Not of these United States. It's just the sovereign nation, the sovereign state is the United States. Sovereign means the ability to exercise control, the only level, the highest level of control over the activities and conduct and rights of the people that live in that area. Ma'am? Autonomous, yeah. That's the only.
When was the Pledge of Allegiance? When did that come into being, one nation under God?
That was legislation by the Congress, and I think it was officially sometime in the 40s, right around World War II. That's what I recollect. Shooting from the hip on this one too. But it was. I think that's this, and there was amended during the Eisenhower administration. Drafted. Yes, sir.
You're talking about that no sovereign state and so forth. A little interesting tidbit. If you're looking at the Declaration of Independence, the penmanship of Thomas Jefferson or whoever was describing there, when he comes out to say United States of America, United is not capitalized. It's not part of the country name. It's an adjective.
The United States.
And the United States of America.
That's right.
That speaks volumes.
That's right. They didn't have any concept at that time to be permanent. And here's the one thing to remember, that before you had government, you had law. Law has existed before any government in our concept. But the English have a concept of parliamentary sovereignty. That they didn't have law, that they don't see it that way. The government created the law. The law didn't create the government. I'm sorry, way over there somewhere. But the point is that when people settled here in this area, they had the law before they were a country. Before they were anything, you applied the law. You had to have it. I'm sorry, I've gotten far afield and I may have made my statements confusing. Anyone else?
No. Excuse me, go ahead.
Tom, go ahead.
After the Civil War in 1866, there was an attempt, I may be a little bit off here, but to put Jefferson Davis on trial, but they were afraid to, as I understand it, because the court system may not be friendly to them in that regard. In other words, that sovereign states thing, Shelby Foote, the historian, the Civil War historian, said some words to the effect. The states would not have joined the Union in forming the Constitution if they did not think they would never be able to get out. You follow the issue?
Well, some of the states, I think you're right, thought that when they signed on to the Constitution, they could withdraw from it at any time.
And within the two state ratifying conventions of 3 of the states,
we're in this together, folks, and as Ben Franklin said, we either hang together or we hang separately. Now,
isn't there an inequity in the 3 branches of government, with the legislature having more power over the judiciary than?
I don't. There are from time to time certain situations that give more leverage, but the Supreme Court, contrary to somebody's belief in this nation, cannot be abolished without a constitutional amendment. How many of you want to destroy the federal court system? Not one of you, I assure you, because if you've ever been through, your rights are protected, and taking rights from other people does not grant you any rights. That's an axiom, but they're balanced because Congress creates a law, somebody tries that case, it goes up on appeal, Supreme Court can say yes or no. That's how they can check the action of Congress, is on the concept of constitutionality.
I guess more on the state level than on the state level where the funding for the courts comes from the legislature.
Don't get me started, young lady. the annual budget of the state of North Carolina includes for the judicial branch of government 3%. 3%, less than 3% now, of the state budget is for paying and providing for a judicial system. 3%. Okay. And of course everybody, I mean, no, I'm going to stop now. Yeah? All right, anything else?
Do you have strong feelings about that?
Yes, I do. And while we're at it, we'll talk about the school system. How about that? But I'm not running for office this time.
Hallelujah.
For me, hallelujah. And you're glad I'm not running. I think Bob Brady ought to run, is what I think. Don't you think so, Brady? This is Judge Bob Brady's wife and grandson. And his first name is Brady.
But it isn't Brady.
It's a long story. All right. Thank you all very much for your attention. I hope you've enjoyed it.
I'm Bill Tate with Caldwell County Now and Then, and I am pleased to announce that we are joining hands with our local Caldwell Heritage Museum in a joint effort to further enhance our history for Caldwell County. I'm proud to announce too that I'm now a board member, and it's great to be joining our museum.
Caldwell History Museum could not be more proud to have Mr. Bill Tate here on board. It's fantastic to enjoy the presence of another man who's just as passionate about Caldwell County, if not more so, and its history, and such a wonderful history. And we are glad to have you, sir.
Thank you. And in addition to what we've said here, I'd like to say that Caldwell County Now and Then does not accept donations. And if you like the work we do, please donate to our museum. And what's that address, Colin? Do you remember?
Absolutely. 112 Baden Street, Lenoir, North Carolina.